7:30. I'd like to call the order the Old Bridge Township Planning Board meeting for February 26, 2026. Please rise for the pledge. Danny, could we have a roll call, please?
Mr. De Palma?
Here.
Mr. Lenning?
Here.
Mr. Talama?
Here.
Ms. Cannon?
Here.
Mr. Renner?
Here.
Mr. Petty?
Here.
Ms. Masella?
Here.
Mr. McIsaac?
Here.
Mr. Brennan?
Here.
Mr. Ferrara?
Here.
And Chairman Lauer.
Here.
Yeah, Mr. Chairman, our professionals, I guess, are not here yet, so
Okay.
hopefully they'll be here very shortly. Well, I guess we'll swear them in when they get here.
Okay. Up for nomination and appointments is engineering consultants, CME Associates. Can I get a motion?
Second.
Mr. De Palma?
Yes.
Mr. Lenning?
Yes.
Mr. Talama?
Yes.
Ms. Cannon?
Yes.
Mr. Renner?
Yes.
Mr. Petty?
Yes.
Ms. Masella?
Yes.
Mr. McIsaac?
Yes.
Mr. Brennan?
Yes.
Mr. Ferrara?
Yes.
Chairman Lauer.
Yes. Okay, next is up for discussion, special meetings. First one is 53-2025P, Walmart Real Estate Business Trust. Let's open it up for discussion.
So, Danny, there's special dates or something that they're asking for?
Yeah, Joe, do you want me to put the dates into the record, or?
Yeah, there's
Okay.
no issue with that.
Yeah, so
It will
they,
be a public meeting, so.
yeah, so application 53-2025P for Walmart, they had requested Monday, March 16th, Monday, March 23rd, Tuesday, March 24th, Monday, March 30th, and Tuesday, March 31st. They are right now scheduled for the May meeting of this year.
Well, I know, I'll speak for myself. I know I'm not available on any of those days.
Anybody available on any of those dates?
I'm not available.
With the, I have childcare issues, so
Okay.
I have the annual meetings scheduled, but additional ones are very difficult.
Okay. Anyone else?
I won't
I'm
be
not available for any of those days either.
Okay. Okay.
Motion to move it,
Wait, a motion to move what?
to vote on it?
Well, I think there's nothing really to vote on it. It's just a matter of whether, I think the chairman just did is what we needed to do was to find out if we had a quorum that would be available any of the dates that were provided. If so, then we could schedule the meeting. If there isn't a quorum for any of the dates, then we have to advise the applicant that none of those dates work out.
Okay.
And I
Danny,
think
can
we
you
did that
repeat
for-
those dates?
You want me to repeat the dates? So you have Monday, March 16th, Monday, March 23rd, Tuesday, March 24th, Monday, March 30th, and Tuesday, March 31st.
Okay, so how many people can make it?
Make any of those?
Any of those?
One?
I may be able
Okay.
to make the end of the month. I'm having a knee operation on the 12th, so I'll be out of commission for a while.
Joe, I think it might be easiest to go one by one,
Yeah,
say yes or no. If yes, what dates?
Yeah, we started to do that before. Let's just kind of get it in order for the record. Why don't we go down, Mr. Chairman, if it's okay, down the
Okay.
line, just if any of those dates work and which dates they did work, which dates would work for you if it is. I think that's the easiest way and cleanest.
Oh, I'm not available for any of them. So,
No, that's
I'm
fine.
not available for any of the dates.
I'm available for all of them.
At this point, I think I'm available for all of them.
Not available at this time.
I'm only available for 323.
I'm not available at any time.
And Chairman Lauer.
All of them?
Yes? Yeah, we would have a quorum.
All right, I guess, Mr. Chairman, with your permission, we'll have Danny reach out to the applicant, offer which dates that we do have available, and let them know how many people are available, because depending on what relief they're seeking, they may, still not want to proceed, if there's a variance relief, depending on the application.
Okay.
But provide that information to them.
Got you. I'll straighten it out with the applicant.
Okay, thank you. Now, number 2, 49-2025P, 335 Green Street LLC.
Thank you, Chairman. Yes, so this is application 2025P. The 5 dates that they're requesting is Monday, March 16th, Monday, March 23rd, Tuesday, March 24th, Monday, April 13th, and then Tuesday, April 14th.
Okay,
The date of the scheduled,
The date that they are scheduled is April 23rd.
Mr. Chairman, maybe we do the same thing again.
I have a question. So they're asking for a few days prior to the already scheduled meeting?
Yes.
For what reason?
They just gave me a
So-
couple of dates.
Okay. Well, I cannot, I don't know, I'd have to look at my work calendar. I think initially when you had sent the email, Danny, I don't think I was available. I think I was away for a couple of them for work, but I'd have to look back. But I would chalk it up as a no until
Okay.
otherwise.
I replied already that I wasn't available for any of those dates.
okay,
I'm still not available.
okay.
Ms. Gannon?
Yeah, March I could do, not, I don't think April.
So just the March dates?
Yeah.
323 in April, I'm available.
I'm not, Danny.
March 16th, April 13th, or 14th. And if you wouldn't mind, can you duplicate those for the previous? Because I think they were similar dates, weren't they?
You want me to read all the dates?
No, for the previous meeting request.
Duplicate those dates?
Yeah,
Okay.
thank you.
I can be available in April.
That one, we wouldn't have a quorum, Chairman. We would not. No.
Okay,
And just advise, I would recommend advising the applicant of that.
You got it.
okay, wanna swear?
Oh, yes, Mr. Chairman. Rakesh, we skipped over swearing in the professionals because you weren't here yet, so if you don't
Yeah.
mind.
My apologies, Mr. Chairman.
No issues. Would you please
I also had childcare issues.
please raise your right hand? Do you swear or affirm the testimony you're going to give this evening is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, we're going to skip over the rules, board rules and regulations, and go right to the resolutions. So the first resolution is 65-2024P, Hook Mountain Associates LLC. That's being moved to March 26, 2026. The next resolution is 35-2024P, Old Bridge Regency Village LLC, extension of time.
Thank you. Good evening, Mr. Chair, board members, and board professionals. Kenneth Pape on behalf of the applicant. Last July, we came before the board and requested a minor subdivision approval to create separate tax designation for the target property that's part of the Regency Shopping Center. And one of the more difficult rules in the Land Use Act is that you have 190 days to perfect the subdivision. And the administrative requirements and the coordination of our engineer and our planner took a little bit longer than that. We have all of our approvals, and we're probably 30 to 45 days away from having our plan, or having our maps ready for filing, and we're respectfully requesting one extension of time, and I believe that the extension of time is supposed to be a 6-month extension. So we're asking this board for 6-month extension so that we can perfect that subdivision. Thank you.
Okay. Okay. Do I have a motion to approve?
I'll move it.
Okay.
Mr. De Palma?
Yes.
Mr. Lenning?
Yes.
Mr. Talamo?
Yes.
Ms. Cannon? Mr. Renner?
Yes.
Mr. Petty?
Yes.
Ms. Masella?
Yes.
Mr. McIsaac?
Yes.
Mr. Brennan?
Yes.
Mr. Ferrara?
Yes.
And Chairman Lauer.
Yes.
Thank you all.
Thank
Good
you.
night.
Good evening. Okay. Next, we're going to adoptions of the 2026 Planning Board Rules and Regulations. We just received it via the Township website today. I think it's a lot to absorb in such a short time. I'd like to move it to a later date to give us time to compare the new changes to the old rules and regulations. Any comments? I mean, we just received it today. There's a lot of changes, and I really think we should, okay. So,
So you just need a motion to table?
yes,
Motion to table.
okay.
I'll second.
Mr. De Palma?
Yes.
Mr. Lenning?
Yes.
Mr. Talamo?
Yes.
Ms. Cannon?
Yes.
Mr. Renner?
Yes.
Mr. Petty?
Yes.
Ms. Masella?
Yes.
Mr. McIsaac?
Yes.
Mr. Brennan?
Yes.
Mr. Ferrara?
Yes.
And Chairman Lauer.
Yes.
Chairman, is the next March meeting okay?
The one for the 12th?
Yes.
Yeah, that's
Okay.
fine. Okay, next, minutes of January 29th, 2026. Are any comments, deletions? Need a motion to approve?
I'll move it.
Okay,
I'll second.
Mr. De Palma?
Yes.
Mr. Lenning?
Yes.
Mr. Talamo?
Yes.
Ms. Cannon? Mr. Renner?
Yes.
Mr. Petty?
Yes.
Ms. Masella?
Yes.
Mr. McIsaac?
Yes.
Mr. Brennan?
Yes.
Mr. Ferrara?
Yes.
And Chairman Lauer.
yes. Okay, applications for tonight, 04-2025P, 600 Jack Street LLC. Major preliminary and final site plan with a C variance is being adjourned till May 28th, 26. Okay. Next application, 22-2025P, Machaponack Estates, Inc., Brookside Villas, preliminary major subdivision.
Mr. Chairman, before we start that one, you come on up, but, did they notice for that? Is that being carried with or without notice, the prior?
That was going to be my question. They had noticed for this meeting.
I mean, I haven't received anything on a request from them, and it is quite some time since the last hearing, so my request, my suggestion would be that they get carried with notice. They have to provide notice for that meeting,
Okay.
as long as that's acceptable to the board.
Sure, yeah. With,
So if, actually, let me, Mr. Chairman, if I can just make a quick announcement. If anyone here is on, came for that application, the 600 Jack Street LLC, That is being carried to the May 2026, but the applicant will have to provide new notice for that application.
Good evening.
Good evening. For the record, my name is Frank Petrino. I'm with the law firm of Eckert Siemens. We represent Matchaponics Estates, Inc. We have published notice and served notice. We've submitted our affidavit, and I believe the board has jurisdiction to hear this matter.
That is correct.
Thank you. So the property we're going to talk about is approximately 5¼ acres, has frontage on both Colorado Boulevard and Palomino Drive. We're here to talk about a subdivision to create 6 single-family lots and 1 open space lot. We were here 2 years ago. We got a minor subdivision.
It's been 4 years, Frank. 4 years.
Well, time flies. To create this 5-acre parcel and 1 other, and now we're back to subdivide the 5-acre parcel into 6 house lots and 1 open space lot. 4 of the lots are proposed to have access off of Colorado. 2 have direct access off Palomino. We have received 3 review memos, one from Mr. Lavello from Conservation and Shade Tree, one from Matthew Bond, who I believe is the fire marshal, and one from your engineer. Those are the only review memos that we've received, and I don't think there are any others, at least. Okay. In terms of other approvals that we've already obtained, we have obtained from DEP general wetlands permits, a 6 and a 6A, and those permits also carry with them the verification of the location of on-site wetlands. We have 1 witness, our engineer, Sharif Ali. I think you're very familiar with him. He's been before this board several times. He'll present testimony regarding the existing condition of the premises, the scope of the proposed development, which I've outlined. It's not a large application in the sense of the number of lots being created. And he'll also go through the township professionals' memos. Some of the memos had comments that require testimony. He'll go through those, and he'll also provide a list as he goes through of the will comply items. We have mostly will comply items, but we'll go through that. There are 2 representatives of Matchaponics here tonight, Alex Halpern and Rob Gelbard. They're available. If there are any questions that Sharif can't answer, they're available, but I wouldn't assume that we would have questions for them. So again, my first and only witness is Sharif Ali.
Mr. Ali, would you please raise your right hand? Do you swear or affirm the testimony you're going to give this evening is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay.
Thank you.
Sharif, quickly, by whom are you employed and in what capacity?
Amertech Engineering, and I'm the president of Amertech Engineering.
And Sharif, what's your educational background? What licenses do you hold in New Jersey? Oh, thank you.
So I still have my license in good conditions, good outstanding. Graduated from NJIT back in 85, 89, received my license, and since then I've been practicing land use engineering and been before your board and numerous times, as well as board throughout the state of New Jersey.
All right, Mr. Chairman, we offer
You're accepted.
Thank you. All right, just a couple of preliminary questions. Sharif, did you prepare or supervise the preparation of the preliminary subdivision plan, last revised July 28, 2026?
Yes.
Okay. Did you prepare or supervise the preparation of the stormwater narrative, volumes 1 through 3, dated September 20, 2024?
Yes.
Did you prepare or supervise the preparation of the operation and maintenance manual for Brookside Villas, dated September 20, 2024?
Yes.
Did you prepare or supervise the preparation of the boundary and topographical survey dated August 6, 2025?
Supervise, yes.
Correct. Did you prepare or supervise the tree removal replacement plan dated August 4, 2025?
Yes.
Did you prepare the environmental impact statement, last revised at the time of submission of the application, February 25, 2026?
Yes.
I think we're going to hear about a revision to that as well?
Yes.
Okay. And did you prepare or supervise the community impact statement prepared and dated July 16, 2025?
Yes.
Okay. Now, a couple of preliminary questions. Do we want to hand out the plans so the board can see them?
The color?
Yeah.
Yeah, I will
Okay.
do that.
I'll do it.
No, I have enough.
Oh, you have
this
enough?
year. Yeah, keep this year.
I got a ton.
Oh.
I got 15.
While those are being passed out, do you mind just identifying the exhibit? And I guess we'll be marking this as Exhibit A1.
A1. Sharif, could you please identify the plan?
Yeah, so A1 is a Brookside Villas color rendering, pretty much of the landscaping plan that we have within the set.
And does that plan identify the 6 lots, the 1 open space lot, and other detail?
Yes.
Okay. So please describe for the board the existing conditions of the 5-acre parcel.
So you heard that we have 5.3 more or less of an acres in the R20 zone. The R20 zone is the 20,000 square feet lot area zone. So we, and you also heard that we are, the site is identified as lot 29.11 in block 24303, and that shows on the township tax map, sheet number 24.15. So with that said, the subject site was before you 4 years ago, back in 21, for what we call a minor and consolidation lots. There were a bunch of lots there, and lot 2911 was created or was born out of that subdivision, and that was your board. The lot located pretty much and surrounded by Rocky Creek subdivision. That's a subdivision that took place and I believe is fully developed now, maybe with the exception of 1 or 2 lots. So I would say back in the mid 2000, and we shoved This lot is shoved pretty much in the northeastern quadrant of the intersection of Colorado and Palomino. So if you add there, you'll see it's from the street, appears to be wooded, but if you go behind the woods, it's pretty much open area there. So the site is partially wooded. The wooded area that you see from the street, which used to be designated as Lot 1, and if you recall back when we did created the minor subdivision, Lot 1 was owned by the township and was given back to this subdivision to be maintained as open space as it used to be. And at that time, it was 1.4 acres. Within Lot 1, you have an isolated wetlands with a 50-foot buffer. 99% of the wetlands is located on Lot 1. And back then, Lot 1 had non-critical area of 28%, which is way below what's your ordinance required. So our proposal, the site, as I said, it's wooded, as you see it from the street, contain a piece of wetlands that was already confirmed by the state of New Jersey, wetland section. The rest of the site is pretty much open area. There is a trailer on site. I believe the boys from JCP&L, they use that trailer. There's an overhang wire with that and a utility pole and a driveway. So that's what's out there right now. Our proposal is that to remove the overhead wire, the utility pole on site, demo the shed in the back of the site, as well as remove the trailer. And proposing 7 lots. The 7 lots will be 6 residential lots, meeting the R20 zone. We in full compliance with the R20 zone. We're not seeking any variances on the lots or design waivers. Fully complies. The 1 lot remaining that's about 1.9 acre. That will be open space, will contain the wetlands on site, as well as the majority of the wooded area, and on site a stormwater basin. So that's pretty much the existing condition, and that's what we are proposing. There is sewer and water, electric, gas, everything under the sun out there. Access to the 4 lots will be provided by a cul-de-sac roadway type. That right-of-way and the cul-de-sac itself, it meets the residential site improvement standards. So we're not asking for any waivers from residential site improvement standards. So that's the standards out there. So 4 lots, pretty much on one side, and that's the reason we are proposing one side sidewalk. The other 2 lots, as well as the detention basin and to access, well, let's not call it detention basin, stormwater facility. And to access the stormwater facility will be off Palomino. So 2 lots will have frontage on Palomino, as well as the stormwater facility, and 4 lots will be on the future cul-de-sac. A public right-of-way will be given to the town as a public roadway, and will contain the 4 lots with the driveways. Again, we are meeting the residential site improvement standards with respect to the driveways, the roadway, the cul-de-sac, the number of parking spaces that is required for each residential home. Part of the improvements that we also proposing as part of the 6 lots residential subdivision here is a stormwater facility, The stormwater facility contains a few inlets that capturing most of the runoff from the future cul-de-sac, taking it to underground treatment facility, treatment device to meet the water quality and the state of New Jersey stormwater regulations. The site is not rechargeable, as well as you probably heard about that so many times. Any subdivision comes in the area, in this particular area, whether it's Rocky Creek or a bunch of the old residential home there, Woodhaven, you will hear that that area is not rechargeable. So with that, we we do not need to address the recharge requirement. The stormwater facility is meeting the state of New Jersey PNP manual, best water management practice, as well as the green infrastructures with respect to water quality, as well as the reduction storm, what we call it, the quantity storms, the 2, the 10, and the 100. The end result is that the big runoff comes from the site for the 2-year storms is less than 50% what occurring out there. So with that, also we have, we're gonna do some tree clearing. I've been in communication with Mr. Lavallo. We're gonna have, once he comes back, we'll have a site visit. We will locate every tree on site, as well as a specimen. And with his blessing, will be again a tree removal from his office. We're also in communication with the fire department. We provided them with a turnaround auto term, the largest fire truck you have in town, and also a fire lane along the cul-de-sacs. That has been taken care of, and it's been plussed by the gentleman. What else did I miss? I think I pretty much covered everything. We also have a small sign that we'd like to have for just like any residential community. Our sign will be called Brookside Villas, and we'd like to have that at the intersection of Palomino and Colorado Drive. That's a small sign, 20 square feet, 6 feet high. It meets all the ordinance requirement. So we're really not seeking any design exceptions or design waivers. What did I miss?
Brookside in Colorado. This one.
Sure.
Okay.
So I've been told that the sign will be at, well, Brookside, the future street name that we have on the plans, we heard that we already have Brookside in town. So we'll be reaching out to you guys and changing that.
Okay.
So the signs will be at the future cul-de-sac intersection.
Couple of questions. One of the requirements or comments in the memo from the fire marshal was that you revised the fire truck circulation plan, and have you done that and submitted it to him?
Yeah, as I stated before, we already been in communication, email communications, and and we, Matthew Bond, Mr. Bond.
Yeah.
So we already provided him by email he gave us the largest vehicle, and we demonstrate that it makes a turn on the cul-de-sac, and he was happy with that.
Is this the plan that you submitted to him?
Yes.
Mr. Petrino, is this going to be marked as an exhibit?
A2. Can you just identify it for the record?
I don't think you have this electronic. That was produced a few days ago for Mr. Bond.
And how is that plan different than your original submission?
It's the same design of the roadways. We just demonstrate that the truck will make the turn.
So you put the template on and it complies?
Yes.
Okay. Now, we were also asked to provide a revised environmental impact statement, and that was done as well and submitted to
Mr. Lavallo.
yes, Mr. Lavallo. So that's been submitted, but we have not gotten a comment from him on that.
Yeah, I believe he's away, and when he gets back, we'll have a field visit, and we'll go over the tree specimen, the count, and as of, that was today, at 8 o'clock in the morning, we sent him the revised EIS to meet his requirement, and I'm pretty sure that we'll get his blessing on that.
Are there any other comments, either from the fire marshal or from the environmental official that we're not able to comply with?
Not at all. We'll comply with all the recommendations, yes.
Okay, so let's go to the ERI Planning and Engineering memo. There are issues in there that it was suggested testimony might be required. I know on most of those, on many of the comments, if not most of the comments, your response is going to be, will comply. But can we go through that memo quickly for the members of the board?
So, Mr. Chairman, I'll leave it up to you. I can go through the whole entire memo or just pick on the one that we would like to discuss. The rest of them will comply.
I'll let that, Mr. Rakesh.
I mean, I think the most efficient would be to just the comments that are giving you some heartburn. Let's discuss those.
No heartburn.
No heartburn. That's what I love to hear, Frank.
All right. So,
First comment is 4 on page 3. I don't know if the board members have the report available to them, stated February 19th or February 20th.
yes, so the first comment is on page 3 of 14, within the bulk requirement. You'll see one of the bulk requirement has been flagged as a variance. That is for lot 29.11. That's the open space lot. And you heard my testimony that 29.11, that was 29, here's a confusion. 29.11 is a tax map large lot. The future lot open space is also will be called 29.11. And all the lot numbers being confirmed by the tax assessor. So that's one of the items in the memo. So the future 29.11, the open space lot, as I mentioned before, that was a bunch of, it was created from the minor and was created generally from the original lot 1 that was an open space lot. The non-critical area, as I stated before, in that lot 1 originally was 28%. We improved that. We took it up to 43%. But the ordinance, and I believe the spirit of the ordinance is that it's talking about residential lots, that they have to have the minimum non-critical areas. So if you have a house, you have a driveway, you have a swimming pool, and you have the backyard activities, you have to make sure that that particular lot that you are creating has 65% of non-critical areas. Non-critical areas meaning flood hazard, wetlands, buffers to go along with that. It could be steep slopes, specimen trees, so that's a non-critical area. But that particular lot is an open space lot. It was born as a open space lot back when Rocky Creek created that lot. We improved that situation of the non-critical area from 28% to 43%. So with that said, that's our testimony as far as if it's a variance, yes, we will be taking that. We would like to ask for a variance, but just keep in mind, it's not a residential lot. And the spirit of the ordinance is for residential lots.
Two comments from my point of view. One, I don't think we need a variance because it's not a lot to be improved with a residence. And secondly, it's an existing condition. We're not going out there and removing material and somehow now not hitting the 65%. So in the planning and engineering memo from ERI, it says, well, you need a C1 or a C2. If we needed a variance, it would be a C1, and it would be because of the existing condition, and it really doesn't require any planning testimony. It requires just a recognition and an understanding that it is an existing condition.
I would tend to agree with Mr. Ali and with Mr. Petrino on that. The non-critical area, the intent of that requirement is really, if we're creating a residential lot, to make sure that the property owner isn't burdened with a non-usable area and there isn't enough room for actual, use. And further, the area that we're talking about was the open space lot from, it was called Matchbonics Estates, actually on the final plat, I believe. So that was the open space lot that was there. That was to be conveyed to the township. It never was actually conveyed to the township. And then that was combined with this property as part of that minor subdivision, which was actually what was directed in the resolution of approval for Matchbonics Estates. So basically, we took this piece, which had a lot of, or a large percentage of non-critical area, made it part of, combined it with a couple of parcels that then reduced the increased the non-critical area percentage. And now we're going back to, again, creating this lot, which will have a large non-critical percentage. At the end of the day, it's sort of a shell game of sliding the land around. There's no change being made to the actual non-critical area. So I would tend to agree that it is a C1, and in this case, it would really be more of an acknowledgement that there's no detriment that's actually created by the grant of that relief. How's that?
Yeah, Mr. Chairman, I agree as well.
Thank you.
On a legal basis, I think it's important that the board does act favorably on the application, does grant it as a variance, because while it may not be the intent, and I agree with everything that was stated on both sides of the table, but there is no differentiation in the ordinance itself, so it's really more of a technical variance that would be granted as part of this application.
Yeah, I agree. It is a variance. The one thing we'll disagree on, I think it is a variance. So, yeah, I agree with Joe.
Sharif, yeah, we're up to page 4.
So page 4, under waivers, number 6, as I stated before, we meet the standards. We meet the residential site improvement standards. They are the gospel. So I think the waiver will be from the ordinance,
Yes.
not from the standards. Number 7,
Well, let me just stop you. But the ordinance is superseded by RSIS.
I agree, but it's been the board's practice that they would have to actually entertain the waivers. So,
Okay.
because it is in our ordinance, it is a requirement in our design standards, but it is superseded by the RSIS. We wouldn't change our ordinance only because there are applications that come through that are not subject to RSIS, right? So for that
Right.
reason, we have it in our ordinance and it is a waiver. And your justification for the waiver is a good justification. There's a superseding regulation that says, no, this is what it should be. So I agree with you. Of the two waivers, and the same reasoning applies to 6 and 7, Mr. Chairman, number 8 isn't addressed by RSIS. My preference would be to go with a larger radius at the intersection to be consistent with the rest of the development, because I believe the rest of the development has at least 20-foot radii at the corners there.
yeah, I think you meant to say number 7.
I'm sorry, I meant number 7, I apologize.
seven.
Number 6 and 8 are per RSIS. Number 7 is the radii at the intersection, where the applicant's proposing 15 feet. Our ordinance requires 20 feet, and the existing development in the neighborhood, I believe, might be 20 or 25. We want to be consistent with the rest of the development is the idea.
Does Exhibit A2 satisfy the board's engineer?
A2 is great, but again, we want to be consistent with the rest of the development.
Yes, so we'll comply with that.
Yeah. Did you increase the radii when you did A2? Is that what you
Yes.
did? Okay.
Yeah.
I apologize, Frank, I didn't realize that's what you were getting
So
at.
number 7 will go to, as you recommended, 20 feet.
Okay, perfect, thank you.
So in number 9, Sharif, do we have 2 items to talk about, D and E?
Number 9, we always get in trouble on.
I think number 9 is, we'll work it out.
Number 9, yeah,
If the board acts favorably, the lighting has to be consistent with the rest of the neighborhood,
yes.
and we'll work that out.
Yeah, so, to just, for the record, is that okay if I continue on?
Oh, yeah, please,
Okay.
I just,
So for the record, number 9 it's mainly for residential areas that, like Woodhaven out there, where you have condominiums, you have apartments, you have townhomes, and you have common parking lots. So it was meant for that. What we have here is a future public right-of-way, and if you read number 9, if you go down to D and E, it talks about illumination of residential areas, which is kind of like gives you like, what are we gonna do the front yard and the side yard and the backyard? We're not obviously doing that. So that's the reason we asking for a relief from that. But it's in the ordinance.
yeah, my recommendation, again, should the board act favorably on the application, would be to grant relief from the lighting standards to the extent that they can't comply, but to the satisfaction of our office and to Ms. Shapiro's office.
Number 10 on the same page, we are confirming that the garage will be a minimum of 18 feet deep. Typically, a garage is 22, but we are saying we will comply. So for that. And then on page 5,
Well, let me stop you for a second. Is 11 will comply on page 4?
11, that's.
And you've already done it in the EIS.
Yes,
In
and
the
I already
revised
put the
EIS.
testimony on that we are already in communication with Mr. Lavallo.
Yeah, I think what we were asking is confirmation, because what you have is a 50-foot by 50-foot sample area, and what we're asking is for confirmation that the vegetation is consistent throughout the site, because the sample area is great if the vegetation is consistent, but if you have areas that are disparate, then you would need multiple sample areas. So what I'm asking is the vegetation that's in the 50-foot by 50-foot sample area representative of the entire site?
Yes.
Okay.
And I think
Frank, you want me to keep going?
yeah, in the environmental impact statement revised January 25,
Okay,
it confirms that.
perfect.
Yeah,
Keep going.
keep
So,
going, just indicate will comply, and then at 12, a will comply.
Yeah, so as I'm skipping, meaning that we will comply. Number 13 will, it talks about that a testimony to, as far as the solid waste. This is a residential community and curb pickup and a private hauler. That's our testimony on that. Number 13 on page 5.
Thank you.
So your testimony is that it's going to be private hauler, not?
Yes.
Okay.
Number 14, I think we touched base on that, number 14. So number 14 talks about the sign. And I labeled the exhibit as a color exhibit. And I labeled that as A3.
And what's in the title block? What is it called?
A signage plan, Brookside Village signage plan, and it shows a very simple sign to be at the future intersection of the future roadway there, as is shown on the plan as Brookside Drive, and we talked about we will change the name. And it shows the location of the sign, and also shows the sign meets the ordinance requirement, 20 square feet, 6 feet high, and we'll have a couple lights on the ground aiming to the sign. So the sign is not illuminated, and just 2 lights at the bottom in the ground.
Ground-mounted signs.
Yeah, ground-mounted, yes. So that's our sign, and that's our testimony on that.
Okay, so we're passing down to, or we're moving down to 17 on page 6.
17, I think is just a confusion there. We were
Right, we're
asked-
only seeking preliminary approval.
Right, we were asked to provide a final plat. So the confusion there is that because we here for preliminary, or of our plans called preliminary major subdivision, but because it's a final plat and we asked to provide it, so it says on a final plat. It is a final plat. So I'm just clarifying that.
So it's, you're only seeking preliminary approval this evening?
Right now,
Correct.
we will be
Okay.
seeking, yeah.
All right.
That's what our notice indicated.
Yeah, your application said and everything. The confusion was that since there was a final plat provided, I just wanted to make sure.
Right.
Well, we did review the final plat, so you have comments for when you do come in for final. That should be a really quick evening.
We'll definitely take care of it.
So 18 through 22 are will comply.
Yes.
23, my office received from the tax assessor the lot numbers that we're using on the subdivision plan. 24 through
48
48 or will comply.
will comply. So number 49, it's recommended that the sidewalk to be on both sides. We have it on one side, and as I said before in my testimony, that the 4 lots shoved to one side of the road. The other side of the road is environmentally sensitive area, and the permit that we obtained from the state for wetlands disturbance, one of the conditions in the permit is that we have to do the minimum to disturb wetlands and associated buffers. So the minimum meaning, if you're looking for a roadway and a curb to get the cars in and out, that's great. That's all you're gonna get. But unfortunately, we have a sidewalk on one side, but that serves the purpose. It's a short cul-de-sac. It's only about 200 feet, and all the residential lots on one side. And
Yeah, I
that's
mean-
what we have on the plan.
My only comment on that is, if you look at an aerial view of the rest of because really, you're gonna have your own sign, which I kind of question why you would need a sign for this little development when you're in the center of existing development, which I guess I'll let the board discuss that. I don't think a sign's necessary, but let's go back to talking about the sidewalk. The rest of the neighborhood has sidewalks on both sides of the road, majority of the roads. There's one road, I think Colorado might not have it because of the way the development laid out, but the rest of the development does have a sidewalk on both sides of the road. I think it's really important, especially given the fact that you might have on-street parking. So if someone's parking there, they're gonna want a sidewalk to get to where they need to go. The fact that you already applied for a permit before you came to this board for approval, it's not that, it's, you know, I'll let somebody else say it's not our problem, but it's not our problem.
I'll say it. It's not my problem.
So,
Let me just point out on A1,
uh-huh,
yellow is the sidewalk.
yes.
In front of every lot. And I'm sorry, it's in front of every lot. There's only 100 feet missing, and then there'll be a crosswalk.
I wouldn't want a crosswalk where that sidewalk is ending in the middle of the road like that. We wouldn't want a crosswalk 100 feet off of the road like that. So if there is one proposed, which, let me see, I don't see it. No, there's no crosswalk, it looks like there, but, I mean, my preference, again, would be to be consistent with the rest of the neighborhood. We don't want this to be different than the rest of the neighborhood. If this is getting approved, we want it to be consistent with the rest of this area, right? So we would want sidewalks on both sides of the road. At least I would recommend. It's up to the board, they're the ones that decide.
Okay.
So sidewalk, I'm assuming you're making a reference to a concrete sidewalk.
Yes.
Not just, we can address the area with mulch is only 100 feet.
Mulch isn't a sidewalk.
It's a pathway. I mean, a sidewalk, we
It's
need,
not.
yeah.
So it's not a sidewalk, it's mulch. So it's either going to be a concrete sidewalk. Let's not conflate that something can be a sidewalk. Grass could be a sidewalk too. I could walk on grass, so it's a sidewalk.
I got you.
So, the 100-foot segment, if the crosswalk was moved, I mean, again, it's, every lot has sidewalk in front of it.
The crosswalk isn't the issue. First, you can't have a crosswalk 100 feet off of Colorado. That's actually a hazard for pedestrians. So we wouldn't want that. We want it to be again, when I say we, I'm using the royal we. I would recommend that it be consistent with the rest of the development. That's basically my point.
So you're asking that
Because
the
sidewalk already.
wetlands permits be modified?
If you can fit it within the existing disturbed area, great. If not, then yeah, you would have to modify the wetland permit. At least that's what my recommendation would be again. Because you have sidewalk along Colorado as those folks are coming up. You know, again, it makes sense that you would continue the sidewalk. I'm surprised that it wasn't done that way.
Sharif, I think that was 49. We have 50A, but will comply 50B. You wanted to mention something? B. 50B.
Oh, the street names, we talked about that. So
Okay.
We'll change the name.
All right, at 51, the only, we do have the permit,
Yeah, you guys just provided that testimony.
right?
You're right, yeah.
And the
So-
permit does delineate the wetlands, so that satisfies 51.
52, page 8 or 14, talks about homeowner association, the deeds. Yes, we'll provide.
Will that be a condition of preliminary or final? I mean, assuming we got preliminary.
I mean, typically, those are usually conditions of final
Yeah.
versus
Yeah,
preliminary. So
yeah.
I wouldn't have it, legally, I wouldn't have an issue with that unless any of the board members.
Yeah, if the board acts favorably on the board acts favorably on this application, we would expect those to be submitted as a condition of prior to signature of final plats, basically.
Thank you.
Could we also get clarification on what the HOA would be responsible for?
Well, it has to, let me look at the plan. It has to maintain the open space lot. It has to maintain the basin. If there are any off-site improvements?
No.
Nothing in the, all right, so it's basically the open space lot in the basin. The road is, we're proposing the road as public.
Yep.
So the HOA would not be responsible for that.
If I may, that's actually what, that's me over here. That's actually one of the things that we were asking with that comment, Mr. Lennig, just some clarification on what the HOA would be responsible for. Particularly, there's extensive drainage in these properties as far as there's within the rear yards, within the side yards, there's pipes, there's inlets, there's drainage manholes. Mr. Lennig doesn't want any of that. So the HOA wants that, is basically what we're getting at.
And we can draft it so we have the ability to go on
Right.
individual lots and maintain all components of the stormwater management system, and that's the way it would be drafted.
That's perfect. That's exactly what I was getting at. And then the other, and this is language I think we'll have to work out should we get to that point, with regard to fences and things like that within these easements.
Yes.
As a municipal engineer for a few towns, one of my bigger headaches is arguing with a guy who just paid $1 million for a house and telling him he can't put a fence in, or girl. Mostly guys, though. So that's one of the things that we're going to need to discuss is exactly, what's going to be allowed in the easements, and things of that nature. But that's something we can probably do at final.
Yeah, we can work out the scope of all of the items at the HOA. We need to know that because we have to prepare a budget.
Yes.
So we need to know all those items.
Yep.
I'm sorry, Sharif. 53, will comply. 54C, I think you wanted to talk about that.
I think we already started talking about that.
Okay.
Talking about the fence and a recommendation to what's allowed in the within the easement. That particular fence is related to the stormwater facility. What we propose in see-through fence was landscaping, massive landscaping in front of the fence, between the fence and the 4 feet deep block wall in the stormwater facility. So the condition out there to just that's okay. Oh. So the area I believe that we are talking about is lot 2915 and 2916. So the stormwater facility is sharing a common property line with future 2916 and common property line with future 2915. So as we stated, the whole entire stormwater facility will be maintained by homeowner association as well as the access to get into it. The basin is delineated with 4 foot high wall, which is pretty much standard landscaping wall. It's not that more than 4 feet high, because if it's more than 4 feet high, then we call a structure wall. But this is a landscaping wall, typical walls that you see out there. The fence is recommended because you have the drop off in the basin area. So the fence is 4 feet. We're recommending, shown on the plan, 4 foot high, easy to get in and out, or a resident or someone in the area can see through the fence that if someone down there for a safety purpose. So that's the reason that see-through, 4 feet high. and to give also some security and to address the area around this, the storm facility, is that we have quite a bit of landscaping, evergreen landscaping to hide the fence and also hide the stormwater facility. Just like a typical any subdivision that you have in town. So so that's what we have on the plan, and I believe the recommendation is I don't think it is recommended the proposed fence to be provided as non-scalable fence.
Yeah, typically for drainage basins, what we would prefer is a split rail fence, whether it's PVC or, probably it's, HOA is going to maintain it. I would want PVC just because of longevity. PVC split rail fence with a mesh, with a small mesh, so it prevents it from being climbed.
So we'll take the recommendation and we will comply. Number 58.
So 55, 56, 57 will comply.
Yeah, we're skipping the meaning complying. Number 58, it talks about condition of, okay, so as taken back lot 1, so we took the whole entire frontage of along Colorado and Palomino. So with that said, any sidewalks or traffic devices along that entire frontage will address whether it's broken or splitting, or we'll take care of that. So we are in agreement with that.
Are those sidewalks on our lot or in the right-of-way?
Within the right of way.
They're in the right of way.
All right, so you want us to do that work in the right-of-way?
Correct.
Okay.
They're all in good shape. Even
Yeah,
with the snow cover out there, I see much
I haven't-
panic associated.
Yeah, I haven't been out there in a while,
Yeah.
but based off, it's been a while, yeah. So but based off the street view, it seems like it's in pretty good shape. But
Yeah.
that is a requirement that we have on
condition,
most
yeah.
developments.
All right. So you ask us to put a testimony on it. We're good with that. We already talked about item 59 on the same page, page 8, the overhead wire, and I said that will be removed.
61 or will approve, will comply.
Yeah, and 60, just to clarify, there's a typographical error. It says parking is prohibited on both sides. It's actually parking is prohibited on one side because of the 28-foot width.
Correct.
Item 60.
I am 60, yes.
So we're up to 62.
Yes, we're
Or is
almost
that a
there,
will
gentlemen.
comply?
You know, I think I already covered 62 too. It's talking about probably an existing stop sign and a bar.
That was
right?
covered in the same testimony from
Same.
59.
From 59.
So 63 through 66 are will comply. Now, we're on page 9.
So page 9, we were asked to put a testimony on one of the easement where is a manhole. Actually, we'll combine 67, 68, pretty much the same. So we'll work with your office, with your engineering office, and we'll shift the line to make sure that a minimum of, right now we have 10 feet, we'll make sure that a minimum of 15 feet away from the basement wall.
Okay.
Or better. So we'll comply with that.
All right, 69 through 76, we're on page 10, our will comply. 77, we already talked about, that's,
Yes.
we've met the DEP standards. We had to go through stormwater review to get the wetlands permit. Redeem, did you already cover A, B, C, and D? I think you did in 77.
Yes, we'll comply. We already,
We already, our stormwater management system met DEP standards.
So
Yes.
one thing that it doesn't comply with is the future storms. We didn't see any calculations for the future storms, and you do have to comply with that. So that's something that we'll need.
yes. So my apology on that. We already, the stormwater report keeps on getting bigger and bigger, and it's like, by the time you just go halfway, you'll be
You
falling
can charge
asleep.
more to prepare those kind of reports. What are you talking about?
So what we do as a consulting now is that right now we have like volume 3. It's like very, very thick report. So what we send your office is the future.
So you have the future storms?
We have current too.
Okay.
That we shared with the state. So I will share that with
You'll
you.
share, both the future and the current.
And we meet all the requirements.
Okay.
So
We did submit a revised, that was the EIS. I'm sorry.
Yeah, if it was in there, I didn't see the future storms in the report.
yeah,
That's actually, I actually checked that personally.
yeah. So we have that. That's not a problem.
So 78 through 82 is will comply.
Yes.
And then we're on page 11, item 83, but isn't that the same that it was reviewed and approved by DEP?
No, even say 82, right?
No, 83. 82, you said will comply.
So on my markup is 82. So 83 will comply. That's not a problem. Just change it on you.
Yes.
Yeah, 82, what we would like to get a relief from is that, and I can put the testimony on that, is that they was asking of us is to, since we discharge into an existing inlets on Colorado, we were asked to analyze the system downstream. Can you handle the capacity coming from the site? And in my testimony, I indicated that the rate peak for the 210 and 100 is being reduced. For the 2 years, reduced by 50%. For the 10 years, reduced by 25%. For the 100-year, reduced by 20%. Meaning that what was going there in the pipes out in the street, the flow is being reduced. So what I'm asking for is a relief from going through the analysis, because we already put the analysis in a report with a decrease.
So your testimony is the analysis that we kind of need. So I need that in the stormwater report. The stormwater report didn't have the drainage area maps that we normally look for. So if you could provide the drainage area maps and a narrative that says, here's how much water is going to this pipe segment in the existing condition, and here's how much water is going to that pipe segment in the proposed condition, then that's the analysis that we're looking at. So your testimony and the required maps put in writing.
No problem.
Your testimony put in writing and the required maps are really
Okay.
what we're looking for.
Right. I guess the reason I want to talk about, because I don't want to keep on going for miles.
I'm with you. No, we're not looking for an
Yeah.
analysis of
Yeah.
this part of Old Bridge. We're looking
Okay.
to make sure that the system that's in Palomino and the system that's in Colorado
Absolutely.
can sufficiently handle the runoff,
Yes.
or really the change in runoff from your site.
Sure. We could do that.
So that was that 83, Sharif?
As 84 is about the operation and maintenance manual, which most of that's what's required.
Yeah, 84 through 93 are will comply.
Yes.
So now we're now on page 12 of the report.
All right. So 94 is more of an attorney explanation, but I think it's number 94, page 12. It talks about the street lights, and I think that's more of a condition of the final. If the approving board include the condition of approval for installation of a street light on dedicated public street, and it goes on at 50% of the dwellings, 50% of the floor area ratio, yeah, I guess we will be complying with that. But that becomes part of the final.
That's also the township standard for accepting streetlights, so.
Yeah.
So do you agree that's a condition of final?
Yeah, we can deal with that at final, but just so you know, that's basically what we do.
Right. Number 95, I think that is given. We will comply with that. Developer shall provide for installation of all underground service for street lights at his cost. Any objection?
96 is will comply. Do you need to discuss 97 and 98?
That's a very interesting one. So, the question there is that while we're doing the construction on the 2 lots with frontage on Palomino, which is 2916 and 2917, even with the basin. So the construction entrance is going to be from the future roadway. And then from there, clearing, earthwork, storm, putting the basin, rough grading, that will be coming from inside. So at that time, yes, we'll put a fence all along Palomino that will allow people to travel or to walk on the sidewalk there. The only time that they will not be able to do that is that when we basically doing the work from the existing curb to the right-of-way. In this case, we have 2 driveways that we need to punch through, so we'll be doing some work in that area. So we are talking about temporary disconnect of the sidewalk at that time for a small period of time.
So 98 is no, it won't be built in stages, correct?
No, we only 6 lots.
99, that looks like something's done at final?
99 is okay.
Yeah.
Yes, that's at
Yeah,
final.
Yeah, that's actually, at time of construction, we want the limits staked out.
Now we're on, yeah. Well, he wrote it, I can't.
We like to be thorough.
Page 13. And number 100, do you have something you want to add to that? Or have you already testified to that? That's temporary identification sign detail.
So it's a temporary identification sign. So basically, we're talking about this, is that this detail?
That's permanent sign.
This is a permanent
That's
sign?
a permanent sign.
So-
I don't think we need.
Can we talk about why you need a permanent sign?
It's ground mounted.
No, I didn't ask what kind of sign it was. I'm asking why you need it. The rest of the
Why we
develop,
need
yeah. I mean, it's a 6 lot. I mean, listen, it's up to the board. I'm just asking. It seems kind of unnecessary unless the board really wants one.
Well, my client says he doesn't need it. If the board wants it, we'll, that's what we'll do. Whatever. Okay.
Don't say it.
Now we're on page 13, 101 to 110. I don't see any comments. Any issues with traffic? I don't think so. No.
No.
Um,
It's really more a statement of,
Right. And the administrative that are 108 to 110, they're all, I assume, future
correct.
or final, yes. And Mr. Chairman, that's the end of our presentation.
Well, thank you. I'm glad you only had one witness. Okay, well, let's go to our professional first. If you have any,
I'm really, for the first time in a while, I'm sort of done. We haven't really gone through one of my letters in a point-by-point fashion in a while. I do appreciate it. I don't have any specific questions for this applicant. I think we went through my memo, and they've provided the testimony that we requested and agreed to compliance with just about all the comments in our memo. I'm happy to answer any questions that any board member may have, though.
All right, so Rakesh, so for the, going back to your memo, number 9, which is the lighting.
Yes.
So, and maybe this is for the witness as well. So obviously, I understand that the lighting that's within some of these ordinances are public areas, parking lots and whatnot, but will the proposed lighting match what the current lighting is in that neighborhood?
Absolutely, absolutely, yes.
Okay.
Thank you.
okay, are you finished?
I'm finished. Like I said, I'm here all night if anybody's got any questions.
Dan, you have any?
I only had one comment relative to the position of the sign.
Yes, sir.
And if it obstructed the view when you come to the corner. So
I think it's outside the
but now
site
the sign's
triangle.
gone.
It's an invisible sign now.
Now it's invisible.
Both signs are gone? Both signs.
Okay, questions from the left?
Yeah, with the sidewalk, is that gonna be taken care of with the DEP? Because the painted on the street stop sign, that will all change with the new sidewalk going down there. There'll be a crosswalk there now, instead of the crosswalk you proposed way up the block. That has to be, some kind of stipulation for approval, you know. And that's probably a big to do, having the DEP approve. Now you gotta put a sidewalk there. For safety of the residents and the existing residents. If anybody wants to walk up that one side,
We have to.
there has to be a sidewalk and a crosswalk, like a normal street.
We'll talk to our environmental consultant, Mike Francis, who got the permit for us. If we can put a sidewalk, if there's any way that we can do it that doesn't require DEP, or we'll have to go back to DEP. But I think the issuance of that permit should be a condition of final, not preliminary. We should be able to get to final, and then before starting construction, have that permit. The department, on this particular permit, the permit was pending almost a year before anybody looked at it. We complained to an assistant commissioner, and the permit was issued in 3 days. So we're hoping that the department is changing the way it processes applications. Wetlands permits are not, do you know the 90-day rule? So wetlands permits are not subject to 90-day rule, but a year is ridiculous. So I think they're understanding that they have to be a little more reasonable and a little more prompt in provide. And since this already has a permit, they're already familiar with it. This only affects about 100 feet. Hopefully we can get that permit quickly, but I don't want it to hold up with the board's approval. If you grant it preliminary, I don't want it to hold up final approval.
So
So if I can just summarize, from what I understand is being said, is that the sidewalk is going to be extended. It's going to be trying to be done under the existing permits they've granted. If they can't be done under the existence, amended permit will be sought, but that will be a condition of final approval.
Yeah,
That's what's
And I'm
requested.
fine, legally, I'm fine with that.
So we could have that as, if we were to grant it preliminarily, but it would be a condition of final that the sidewalk would be put in.
Well, no, I think they're agreeing to put the sidewalk in. It's just if
It's
amendment to the
timing.
permit,
Yeah.
timing-wise, it's not a condition of preliminary, it's going
Oh,
to be a condition-
yeah.
just the permit part.
Yeah, but condition of the final would be all of that done.
Right.
Listen,
Until we get resolution compliance on final, we can't start
Right.
construction.
Correct.
Yeah, if I may, that's exactly what would happen, is you would show the permit, I mean, you would show the, that sidewalk on the plans. If it can fit within your permit, great, you would just show it. If it's not and it requires amended permit, you would label it on your, on the final plans that you submit as pending NJDEP permit, so that I don't forget. And then the permit would be required prior to signature of the final plats.
Right.
Okay, Mr.
So,
McGuire?
and if the DEP doesn't approve of the sidewalk, then what happens?
Then we're back here.
That's all bets are off.
And then the applicant would have to come back and amend their approval.
They'd have to come back for seeking amended approval.
As I understand that there might be an additional cost when it comes to this, but as a person who lives in a neighborhood that had an extension of the neighborhood, in case you, like you can see, for me, you want to try to keep it as consistent as possible, and having a sidewalk 100 feet off, and quite frankly, where the sidewalk ends right now doesn't even make any sense, right? It looks like, all right, well, we just stopped for whatever reason, right? So if you were to say, all right, well, we're putting it in front of all our lots, but then why continue it all the way around? But connecting it, there's children, people are going to be walking. Halloween, I'm looking at, right? Like I said, like when I look at my own personal neighborhood in Old Bridge, when I wasn't living there when they did it, but when they did it, they conformed to make it look as close as possible to as if it was always contiguous.
So, gentlemen, what we'll do is that we'll go and reapply for the sidewalk with the state. Just to prepare you mentally on that, is that you would like to minimize the impact on wetlands and buffer. So with that said, in a condition like this one here, they may ask us to eliminate the green buffer between the curb and the sidewalk, any typical sidewalk out there, meaning that they will force us to take the sidewalk in that area and shove it right against the curb, which you see in a lot of areas in town, but you will have your walk.
You would do it on the one, just the portion that you need to do it on.
Yeah, so
And the
basically
sidewalk would have to
push
be at
it
least
right
5
to the
feet
curb
wide. Yeah.
to minimize the impact on wetlands. So just in case if we go and come back again, we already talked about it, is not, most likely it's not gonna be a green strip down.
Okay, Ed, you had a question?
Not part of what you presented tonight, you have a maintenance schedule for the wetlands and the stormwater treatment. You have a schedule of maintenance for it, and the budget was over $21,000 a year for maintaining that basin. Is that only shared by those 6 residents in the HOA?
It'll have to be, because the town originally was going to maintain that, but as part of the approval a couple of years ago, the town wanted that to be part of this overall subdivision and maintained by the HOA. So the HOA will have to maintain the basin.
So we're looking at access to each one of those residents, to about $3,500 per year.
Yeah,
Just
I
for
don't.
maintaining that basin.
Well, yeah, and they will know that when they're viewing the site and entering into a purchase agreement. All that'll be disclosed. It's not gonna be something that comes up after the fact. I mean, we're not gonna do a homeowner association document and public offering statement like you see in the large projects, but we do a declaration and we do a 2 or 3 or 4 page summary of what it's about. Gelbard will have to give me a budget, and whatever it is, it is. And it'll do, if it's, 60,000, it's divided by, and I don't think it'll be that much, it's divided by 6.
Yeah, and to add to that is that most of the municipalities out there now, they're practicing the same thing. They changed their ordinance. They don't want to take any detention basins anymore. Public Works, they hit them. They feel that private companies, they do, better work. They have the equipment. They have the money. They'll go and do it right. So most of the towns out there that now they gear into remove it out of the ordinance, no more taking over detention basin, give it to the homeowner, let him enjoy it.
And this particular development also has a manufactured treatment device that has to get maintained.
That is
as well.
correct. So we also have an underground that manufacturing treatment device that it needs to be maintained. Public Works is not going to maintain that, I can tell you that. It's way above and beyond. They need to add more employees. They need, it's not working anymore. So with the state new regulation, the green infrastructures, now you find that most of the towns in the whole entire state now, removing that part from the ordinance, no more taking drainage basins.
Okay, Mr. Lenning?
I agree with the basins. One of the major parts with the basins is there's so many different kinds. You know, we could train our staff to maintain one particular basin, but then a different one gets built, and then we have to retrain. So that's part of the reason why the township would not want to maintain any additional basins within the township. You know, the sidewalk for me is extremely important. I've mentioned several times, and I have kids. You know, I want to keep them safe. So I think that's really important to continue the sidewalk all the way down, you know, throughout the new proposed street. The sidewalk that is not fronting any homes, who would be responsible for that maintenance? Would that also be like snow shoveling, stuff like that? The township does have an ordinance, sidewalks need to be cleared.
Well, if it's a public street, I assume that would be the town, you don't want it.
No, the township,
All right, well, we'll have a list of, again, a list of things that the HOA has to be responsible for. And even though that's a public street and it's in a public right-of-way, we can provide for the maintenance.
it's basically, yeah, the township, and it's every town, it's not just Old Bridge. You know, the sidewalk is in the public right of way, but like the last two snowstorms, I was out there with my snow blower cleaning my sidewalk. And I think what Mr. Lanning's question is the homeowners will clear the sidewalk in front of their lots because that's what the township and every township requires.
Right.
But what about the sidewalk that's along the open space lot? And that would be the owner of that lot, which is the HOA.
Again, all I need is a list of things that the HOA needs to improve so we can produce a budget.
You know, moving on, I see you guys have the roadway proposed as a public roadway. I would strongly urge the board to make that a private roadway. You're going to have an HOA, which is already going to be maintaining all the stormwater structures in the backyards, the basin, the sidewalks. So I would just have that included as well. The township currently oversees 200 cul-de-sacs already, 150 dead ends, and 174 miles of roadway. This year alone, we've seen an increase in major snowstorms. It's very difficult for the township to continue to take on additional roadways. So I would request that that is made a private roadway, incorporated into the HOA. We had mentioned names of the road. I actually grew up off of Brookside in Old Bridge. Frank's talking to.
The only comment I would have is that you mentioned we're doing 100 cul-de-sacs,
200.
200 cul-de-sacs. So, and not to make this adversarial, I mean, it's a little selective to say we're going to do 200 and this one more is going to be the thing that crosses the line. I mean, we're proposing it be public. We would do the sidewalks, and you're already doing plowing on the main, I guess that's Colorado? Yes. Colorado, so, I mean, the plow is there, it goes in, it comes out, so.
I'm going to respectfully disagree. That the township only maintains 200. There's probably an additional 300 that are under different HOAs throughout the township. So, you know, sticking with my, you know, keep that road private.
Well, you have a vote and I don't.
So, Joe, I have a question for you. So, council, we would have to do that, right? We would have to take.
Well, just to clarify, even if this board does make it a private roadway, under New Jersey law, if the roadway meets all of the township ordinance requirements and they request it to be taken over as a public road, the township has to do so. So, you know, not to take it away, I know. No, I have a very legitimate point, but it may be, even if the applicant agrees to it now, if the HOA in 3 years says, hey, we want to dedicate to this township to be a public roadway, and as long as it meets all of the township requirements for the roadway, width and so forth, then the township's obligated by law to accept it as a public roadway. Just it's something to consider.
But that's why we have a legal team here.
Yeah, but we wouldn't do any maintenance or plowing or anything like that until post-construction. Till everything is said and done and all the COs are.
Correct.
All
Until
right.
it's, the dedication is
The
accepted.
dedication is accepted. Yep, okay.
And that's typically, that's what's out there in most municipalities. They will do
I
curb to
appreciate
curb.
it. I stick with my,
Yeah,
you know,
yeah.
AC's still punch drunk. I don't think he's slept since the snowstorm, so.
Yeah. No, to be fair, yes, I see your concern. The homeowner association should be responsible of the landscaping and the trees and the sidewalk and the stormwater facilities. That's what I see in all the municipalities out there. But when you're talking about public right-of-way, meeting the township standards, then you see that curb to curb, that's a township responsibility.
I understand, and, I appreciate everybody's clarification. I have to do what I believe is best. So, I'm still gonna, try to fight for that, and,
We're gonna stop arguing on this.
yeah, it's
point.
not an argument, I just, we try to maintain a level of service for all the residents in town, and, taking additional work, with this project doesn't become an additional employee, so, that lowers the level of service for every resident in town, because it sounds easy, loop in, loop out. Cul-de-sacs, on a regular 6-inch snowstorm take 45 minutes to an hour, and then later on we have to send a loader back to clear the mailboxes and, stuff like that because it's difficult to handle. In a 2-foot snowstorm like we just experienced, we've been running 24 hours a day throughout the town to clear cul-de-sacs, so.
Is that what you had in Old Bridge?
The Rutgers hasn't put the official number out yet. I check it every 20 minutes, just to see where we're at. Saraville's numbers were posted at 25 inches, and Manalapan's numbers were posted at 25 inches. So we're right in between, so I'm figuring
Yeah.
we're right in that range.
Yeah, that's tough.
Moving on to the name, I mentioned I grew up off of Brookside. When I was little, I didn't know there was another Brookside because it's all the way on the other side of town. To add a third, I know you guys said that you weren't looking to do that. I don't know if a lot of residents know. Well, besides that, I oversee a new program within the township, the Hometown Heroes Banner Program. They were taken down for winter, but they'll be put back up in the spring. And in my research, there was 6 Vietnam veterans or Vietnam soldiers that were killed. So I would recommend that we start using their names to honor them. Vietnam was a bad
Absolutely.
time in America, and those gentlemen did not get the recognition they deserve. So I think that, if you're looking for a name, I can give you a couple.
I think that's a great idea. My best friend was killed in Vietnam in Laos where he shouldn't have been, so I totally agree with that.
All right, you guys give us a few names and we'll pick one.
Absolutely. Sidewalks. The open lot, like in the beginning, it shows that 29.11, that's gonna be grass, or proposed as grass?
The open space?
Yeah.
Well, the majority of that lot is wetlands and buffers, so we really cannot do anything there.
Yeah.
The rest of that, yes, will
Yeah.
be, if there is grass, the grass will be mowed, yes.
Gotcha. And that'll be part of the HOA as well?
Yes, the whole entire open space lot is part of the HOA.
And that's all I have for right now. Thank you.
I have a question on that front lot too. There is that existing drive now. I think it's Werner Court or whatever. I think it's a paper road. Will that be taken out and then it'll be returned back? Okay. Like, because right now I'm looking at the Google image now. It says a driveway and then it goes, and then, so is that you're going to take that asphalt out?
Yes.
And it's just going to go back
Yeah,
to natural?
We have to reconstruct the intersection.
We're gonna need a demolition permit to take down that shed and other things.
Yes.
And the roadway itself that's there is going to be
And-
taken out and
and,
then just returned?
Yeah, the driveway there, yes.
Okay, Mr. Ferrera?
I'd like to make it clear at what point the roadway and the storm basin area is being accepted for final approval. And the roadway, which I'm sure Joe is correct about, Old Bridge will probably be maintaining it, but all 6 houses have to be completed in order for the roadway to be accepted by the town. All construction has to be completed in all
Well-
those houses.
I'm not sure it's
So-
going to
so
be a
the-
public road.
So the process,
Most likely will be a public road, but I want to make it clear at what point will Old Bridge take over that roadway maintenance.
Yeah, so-
All houses have to be completed.
Yeah, so we have similar, I don't want to say issues, but we have similar developments going on now, like particularly behind Target, like the Oaks. We don't have, those roadways aren't us. They're only dedicated, we have the ability to enforce traffic, but we don't have the road yet. That's up to the developer. So once all the development is done, then they would be required to bring the roadway up to standard, put the final top coat down. Once the final top coat is down, I think as Joe had said, as well as Rakesh, then they could come to the township council and ask us to take the road. And as long as it meets the standards, we're almost required to do so. But it would be post-construction and once all of the roadways up to the standard that the state has for a new roadway.
Are you saying that all the construction may not be completed? Is that
no,
what you're saying?
all construction has to be completed.
Yeah, it would have to be
All
completed.
right.
Yeah, we don't release I'm sorry, Mr. Councilman. We don't recommend release of the performance guarantees until all the improvements are completed to and Township Engineering Department satisfaction. And that means that all the construction has to be done. And then it gets recommended to council to release the performance guarantees. And then it goes on maintenance bond. And it doesn't really officially, it doesn't become the township's headache until the maintenance bond is over.
And I don't think the developer is going to want to put heavy machinery on a brand-new asphalt. As we all know, what happens to our driveways when our cars just park there in the summer.
Okay, anybody else? Okay, I have one question. The basin, is it a detention or retention?
So, I don't know if you attended the last seminar, but.
I did review it, and
Yeah, so, this particular one, they call infiltration basins. So there is no, when I started my testimony, I said detention basin, I said, let me take it back, it's a stormwater facility. So now they call them stormwater facility basins. So it could be infiltration, most likely infiltration basin. So that's an infiltration basin that has 6 inches of sand. And that's the reason Public Works, they hate that, because you need to clean the sand areas like baby diapers. You know, you have to clean the sand, you have to replace the sand, and it becomes nuisance. But to answer your question, it's an infiltration basin.
Okay.
Yeah.
Okay, thank you. Okay, I'm going to open it up to the public. Anybody from the public like to ask questions of this witness?
And Mr. Chairman, since, if I may, just, since this is the only witness that's being presented, we could just have the questions and comments at the same time, so you're not having people having to come up twice,
Okay.
if you would like.
Okay. Questions or comments? Step forward.
Thank you. Hello, ladies and gentlemen. My name is Michael Keller. I live on the map you're looking at in Lot 5 in the upper right-hand corner. I will probably be most impacted by this development. So can I have these passed up to you guys? I have some information that I put together.
Yes, you just need to give a copy to the applicant as well.
Okay. So, you guys can hold that. So in here, there's a letter that I wrote to the EPA approximately a year ago when we received notice that the EPA was taking comments on this. There's also like a checklist in there of my concerns, and then there's a little packet that has this map, a photo that I took a year ago of the area where they want to build lots 2916 and 2917 directly next to me. And then there's the map, the site map that was given to All people who purchased in Winding Brook, this is actually surrounded by Winding Brook, not Rocky Creek. Rocky Creek is the development further back, which is what I had when I selected my lot to be built. So,
Mr. Keller, just not to interrupt you, but just
Yes, of
for
course.
record-keeping purposes, we're going to mark this as Exhibit 01.
Okay.
So that, we have that for the record, and I will identify in the resolution approval or denial, whatever it is the board's final decision, that what is contained in this, being the letters and your objections in the mapping.
Okay.
I have received a 3-page letter dated February 28th, and then a copy of a plan, and I think it's just one sheet. Let me just see. 2 sheets and then a photograph. So are those separate?
Well, I'm going to mark it, the whole exhibit, just to keep it simple. Mark the whole packet as Exhibit 01. And there's also a third outline dated February 24th, 2026. Is that, you have that as well?
Maybe it's in the folder. Let me look.
Because you identified everything I have except that.
did I miss one?
Checklist of
I
opposition.
missed that one.
No, this isn't
Yeah, there's 2
Yeah,
things.
that's
There's a
the
letter
checklist.
dated
Sorry.
February 28th and a
Okay.
checklist dated February 24th.
I thought that was just another copy of one of them. Okay.
Okay, so that whole packet will mark as 01, just for record keeping.
Okay. Let me just, and we're going to listen to all the comments, but if they don't relate to land use and the zoning ordinance, I'm not sure how relevant it is, but having said that, I will be
You
quiet.
need to hear the comment first before we can make that decision.
So my first concern is, I guess, more of a personal one, and maybe something I have to take up in civil court. It might not be your issue. But if you look at the map that was given to us when I purchased in Winding Brook, the area where they want to build these 2 particular lots, 29, 17, and 16, directly next door to my lot, was designated as open space. This weighed heavily on my decision to purchase that lot, as I wanted to be next to open space. And as it was presented to me as open space, is clearly marked on the map, I purchased it. And now a year ago, I received this notification that they want to build 2 additional homes next to me in that open space, which I think is a problem and was misrepresented to me. So that's my first objection. My second objection to those 2 lots in particular is they want to put an HOA in this. And if you build 2 houses next to mine that are in an HOA and mine isn't, you're creating a situation where there's going to be conflict. These people within the HOA are not going to understand why I don't have to pay and they have to pay. And there may be a legal explanation for it, but it's going to create conflict with me and my future neighbors. Additionally, they may not understand that why I don't have to follow their HOA rules. If there's rules about lighting, if there's rule about fencing that they have to follow, and I'm directly next door to them and do not. They will, for all appearances, seem to be part of Winding Brook, even though they're considered to be part of Brookside Villas. And that's going to be an issue. So that's my first set of issues with those 2 particular lots. Additionally, with those 2 particular lots, that land is wetlands. If you look at the photo that I presented you, I took this photo about a year ago. Now, you might remember the autumn of 2024 was particularly dry, and we did not have a particularly snowy or wet winter in 2024, 2025. You can see how wet that sidewalk is. It's like a river. It's like that 10 months of the year. I've lived there for 12 years. It's always wet. Public Works has been there in the past and installed drainage, and it doesn't matter. It's always wet. And you can see the vegetation there. That's Phragmites. Phragmites only grows in wetlands. Now, the state may not have told them that they have to designate this wetlands, but it clearly is. So aside from the fact that they're going to push this water possibly more onto my lot, and I can tell you when I bought my lot, the 3 or 4 lots above mine, which sit higher in elevation than mine, weren't built on. And since those were built, more and more water has been pushed onto my lot. My lot gets wet a lot. So I'm additionally concerned that this water is going to get pushed some onto my lot, creating a bigger water problem for me. Aside from that, you're going to sell to unsuspecting homeowners houses on land that are going to be wet. Now, my house maybe shouldn't have been built. I snuck into my house a number of times while they were building it just to check on construction. For a long time during construction, my house too was 3 feet of standing water in the basement. And until the sump pumps went in and turned on, it was there. It wasn't there once I moved in, but I looked in there plenty of times to see how deep that water was. So more water means more water possibly in my lot, possibly in my basement. And the water that's on those two lots is going to go into those people's basements. So they're going to have a constant problem, and they're going to be unsuspecting. Now, if they do manage to push that water off of that lot into their proposed filtration basin, that water is going to go somewhere. Now, I don't know how often any of you drive over in that area or live over there, but the water ends up in Barkley Brook. And there's a little bridge that goes over Barkley Brook on Englishtown Road. Anytime there's significant rainfall, the water goes over the banks and onto that bridge. Thankfully, not yet to the point that you have to close Englishtown Road. But if you push more water onto it, you may start to have to close Englishtown Road and have more road closures that you already have on Texas Road. There's an additional home near the Wawa on Englishtown Road that water always pours out down onto Englishtown Road and causes a problem. There's also a gentleman, a family that lives across the street from where Colorado ends. There's a large lot there, like a little bit of a farm. And when we get significant rainfall, the water goes over that brook. And I've seen that guy's lot covered with 3 feet of water. And I'm sure he wasn't notified about this, but they probably have a legitimate reason to be concerned about where all that water is going to go. And then additional concerns I have about this are the financial impact that it may have on me, as it looks like the lots that they have designated on this site and the homes they have designated on this site are smaller than the rest of the homes in the Winding Brook and Rocky Creek community, which may lower my home value, as now there's going to be smaller homes, smaller lots directly next to mine, in addition to the people who surround it.
I just have to stop you on that
Yep.
point because this board is not allowed to consider, but legally, effect on property values, on that. So that's
Fair enough.
Land use. I just want to make sure so
Yep.
you're clear and just so the board's clear.
Yep. Let me see.
That's the law.
That's my list of concerns.
Thank you, sir.
Thank you.
I'll be very brief. We're consistent with the R20, which are minimum of half acre. All our lots are half acre or larger. The HOA, when you buy a house in this development, before you sign the contract, you're going to know what the obligations are, what you have to maintain, what the HOA maintains. This gentleman bought his house from, I believe, Woodhaven. Woodhaven is not the applicant here. And the area that he refers to as wetlands was viewed, walked on, inspected by DEP, and they're not wetlands. They were not delineated as wetlands. That's all those are my only comments.
Okay. Any other comments? Go ahead. You want to make another comment?
So while it may be a different company, Bob built my house.
I was there when you installed the pool in the back. I was there when you pulled up the driveway and redid it. I was there, you're right. But I think you like the house. I was there also when you.
Mr. Chairman,
wait.
No, no, that, I'm not, yeah, I'm just,
Conversation, it's not.
I'm just saying, like, to say it's not the same builder is disingenuous.
No, it's accurate.
Okay.
No, if
Hold
you
it,
gotta
hold
have
it.
order here. You gotta come up.
You got to come up to the microphone.
The one other thing I did want to say is if this is going to be a separate HOA community, it probably should have a sign. So that there's some delineation so that those people understand that they're not part of the rest of the community.
Okay. Sir?
Hello, good evening. I just want to second what he said about the ownership.
Give your name. for the
I'm
record.
sorry, Umberto Cordero. I'm in Lot 7. My house is, you're looking at the map. It is directly behind,
2913 and 2914.
that's it, yep. I second what he said about the wetlands as well. I constantly walk my dog and jog, and in that area of the Palomino Drive, I have to cross the street and go to the other side. And if it's wet, I usually just turn around because can't even walk through it or run through it. I do want to second what he said about the ownership. I know maybe different names, but I did deal with Rob throughout the whole building of the house. So that's my comment. Thank you.
Okay, thank you. Are there any other comments?
My name is Lucia Zaffarino. I'm here with my husband as well. We live on 35 Arizona Avenue. We're second.
Wait,
Everything
wait.
he said, we can hear. Whatever the gentleman said, we have the same feeling, and most of the neighborhood around our development feel the same way. We live on 35 Arizona. Across the street from us, there is a failed basin that was never put there. It's filled with water, incredible through the summer. So it is a big issue, and this is like also might be an eyesore for our development, which is really a shame because we have a beautiful development, and now we have something that I don't know what that's going to look like. And actually, we just found out that those houses were going to be built because we didn't receive any notification or anything. We just found out through our friends. That's it. That's all I have to say. We oppose any of those.
Okay, thank you. Any other comments? Okay, seeing none, we'll close the public session. Mr. Attorney? would
Okay.
you
Yes,
like to,
Mr. Chairman.
Read the agreements.
The board's now asked to vote on whether it will approve this application, which is for major subdivision, but at this time, only preliminary approval. The applicant would have to come back for final if it was approved by the board. The applicant, if approved, if voted in favor of, agrees as conditions of approval to the standard conditions, which includes compliance with the board's professional and the township's professional reports, subject to the testimony and the comments that were given as part of this public hearing. The additional conditions that were discussed this evening was, one was the removal of the signage from the application. It was the confirmation that the HOA will be responsible for all open space lot, the stormwater facilities on all of the lots. That's including the facilities that are located on the individual lots, as well as the HOA would be responsible for the maintenance of the sidewalks that do not have specific frontage on the individual residents. The applicant agrees to extend the sidewalk throughout the whole proposed new roadway that will have a new name that will be determined at a future date. They will either obtain, either do it within the existing DEP permit or get amended a permit prior to any grant, as a condition of final approval. And if they can't get either one, and the DEP permit would not be granted with the sidewalk, they will return to the board for further discussion and relief. Those are the other specific conditions that were discussed. So, and the grant of approval would also be granting the waivers and the variances that were testified to. There was only one variance with regard to, a technical variance with regard to the, the minimum non-critical area percentage.
Okay. Thank you. Okay. Do we have a motion to approve or deny or?
We need, yes, I believe, the chairman is calling for a motion.
Motion.
I'll move it.
Okay.
I'll second.
Just to confirm, Mr. De Palma, to motion to approve?
Motion to put it to a vote, yes.
You gotta put it to a vote.
A motion to put it, or vote, okay.
Well, that's, what do you mean? Motion?
Well, we gotta vote yes or no, so.
Right,
we
right,
have
so it's a
motion-
motion to approve, a
vote,
motion
yeah.
to, seconded, and
Yeah.
then we vote, roll call vote. So we have a motion and a second to approve.
Okay. Mr. De Palma?
Yes, based off the fact that it's a conforming project and there are no variances that would preclude this from happening, I would just hope that the developer works with the neighbors to ensure that their concerns are alleviated, and as they come to final, we can address those issues going forward.
Mr. Lenning?
Similar to Councilman De Palma, I'm going to vote yes tonight, based on the fact that, you know, it is conforming, but, you know, I would like that the developer does work with, you know, the residents based on some of the facts they brought up tonight and anything else that might arise during future development. Thank you.
Mr. Talamo?
No.
Ms. Cannon?
No.
Mr. Renner?
No.
Mr. Petty?
No.
Ms. Masella? No. Mr. McIsaac?
No.
And Chairman Lauer?
No.
Chairman Lauer?
Oh, sorry.
No.
So the motion fails by a vote of 7-2.
All right, thank you for your time. It's very unusual that a conforming application gets denied, and that usually means there's some step afterwards.
You can have it. Absolutely.
Okay, we're going to open it up to general public comments. See no hands, are closed to the general public comment portion. I need a motion to adjourn.
Move it.
All in favor? Aye.